Continuation, 1987 Constitution, Article 10, the Local Government, General Provisions, Section 1, the territorial and political subdivisions of the Republic of the Philippines are the provinces, cities, municipalities, and barangays. There shall be autonomous regions in Muslim Mindanao and the Cordilleras as herein after provided. Section 2, the territorial and political subdivisions shall enjoy local autonomy. Section 3, the Congress shall enact a local government code which shall provide for a more responsive and accountable local government structure instituted through a system of decentralization with effective mechanisms of recall, initiative, and referendum. Allocate among the different local government units their powers, responsibilities, and resources, and provide for the qualifications, election, appointment, and removal, term, salaries, powers, and functions and duties of local officials, and all other matters relating to the organization and operation of the local units. Section 4. The President of the Philippines shall exercise general supervision over local governments, provinces with respect to component cities and municipalities, and cities and municipalities with respect to component barangays, shall ensure that the acts of their component units are within the scope of their prescribed powers and functions. Section 5. Each local government unit shall have the power to create its own sources of revenues and to levy taxes, fees, and charges subject to such guidelines and limitations as the Congress may provide, consistent with the basic policy of local autonomy. Such taxes, fees, and charges shall accrue exclusively to the local governments. Section 6. Local government units shall have a just share, as determined by law, in the national taxes which shall be automatically released to them. Section 7. Local governments shall be entitled to an equitable share in the proceeds of the utilization and development of the national wealth within their respective areas in the manner provided by law, including sharing the same with the inhabitants by way of direct benefits. Section 8. The term of office of elective local officials, except barangay officials, which shall be determined by law, shall be 3 years, and no such official shall serve for more than 3 consecutive terms. Voluntarily, renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. Section 9. Legislative bodies of local governments shall have the sectoral representation as may be prescribed by law. Section 10. No province, city, municipality, or barangay may be created, divided, merged, abolished, or its boundary substantially altered except in accordance with the criteria established in the local government code and subject to approval by a majority of the votes cast in a plebiscite in the political units directly affected. Section 11. The Congress may, by law, create special metropolitan political subdivisions, subject to a plebiscite, as set forth in Section 10 hereof. The component cities and municipalities shall retain their basic autonomy and shall be entitled to their own local executive and legislative assemblies. The jurisdiction of the metropolitan authority that will thereby be created shall be limited to basic services requiring coordination. Section 12. Cities that are highly urbanized as determined by law and component cities whose charters prohibit their voters from voting for provincial elective officials shall be independent of the province. The voters of component cities within a province whose charters contain no such prohibition shall not be deprived of their right to vote for elective provincial officials. Section 13. Local government units may group themselves, consolidate or coordinate their efforts, services, and resources for purposes commonly beneficial to them in accordance with law. Section 14. The President shall provide for regional development councils or other similar bodies composed of local government officials, regional heads of departments and other government offices, and representatives from non-governmental organizations within the regions for purposes of administrative decentralization to strengthen the autonomy of the units therein and to accelerate the economic and social growth and development of the units in the region. Next, autonomous region, section 15. There shall be created autonomous regions in Muslim Mindanao and in the Cordilleras, consisting of provinces, cities, municipalities, and geographical areas sharing common and distinctive historical and cultural heritage, economic and social structures, and other relevant characteristics within the framework of this Constitution and the national sovereignty as well as territorial integrity of the Republic of the Philippines. Section 16. The President shall exercise general supervisions over autonomous regions to ensure that laws are faithfully executed. Section 17. All powers, functions, and responsibilities not granted by this Constitution or by law to the autonomous regions shall be vested in the national government. Section 18. The Congress shall enact an organic act for each autonomous region with the assistance and participation of the Regional Consultative Commission composed of representatives appointed by the President from a list of nominees from multi-sectoral bodies. The Organic Act shall define the basic structure of government for the region consisting of the Executive Department and Legislative Assembly, both of which shall be elective and representative of the constituent political units. The Organic Acts shall likewise provide for special courts with personal, family, and property law jurisdiction consistent with the provisions of this Constitution and national laws. The creation of autonomous region shall be effective when approved by majority of the votes cast by the constituent units in a plebiscite called for the purpose, provided that only provinces, cities, and geographic areas voting favorably in such plebiscite shall be included in the autonomous region. Section 19. The first Congress elected under this Constitution shall, within 18 months from the time of organization of both houses, pass the Organic Acts for the autonomous regions in Muslim Mindanao and the Cordilleras. Section 20. Within its territorial jurisdiction and subject to the provisions of this constitutional and national laws, the Organic Act of Autonomous Regions shall provide for legislative powers over, number 1, administrative organization, number 2, creation of sources of revenues, number 3, ancestral domain and natural resources, number 4, personal, family, and property relations, number 5, regional, urban, and rural planning development, number 6, economic, social, and tourism development, 7, educational policies, number 8, preservation and development of the cultural heritage, and number 9, such other matters as may be authorized by law for the promotion of the general welfare of the people of the region. Section 21. The preservation of peace and order within the regions shall be the responsibility of the local police agencies, which shall be organized, maintained, supervised, and utilized in accordance with applicable laws. The defense and security of the regions shall be the responsibility of the national government. Next, Article 11, Accountability of Public Officers. Section 1, Public office is a public trust. Public officers and employees must at all times be accountable to the people, Serve them with utmost responsibility, integrity, loyalty, and efficiency. Act with patriotism and justice, and lead modest lives. Section 2. The President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commission, and the Ombudsman may be removed from office on impeachment for and conviction of culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. All other public officers and employees may be removed from office as provided by law, but not by impeachment. Section 3, Paragraph 1, the House of Representatives shall have the exclusive power to initiate all cases of impeachment. Paragraph 2, a verified complaint for impeachment may be filed by any member of the House of Representatives or by any citizen upon a resolution or endorsement by any member thereof, which shall be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter. The committee, after hearing and by a majority vote of all its members, shall submit its report to the House within 60 session days from such referral, together with the corresponding resolution. The resolution shall be calendared for consideration by the House within 10 session days from receipt thereof. Paragraph 3. A vote of at least 1/3 of all the members of the House shall be necessary either to affirm a favorable resolution with the articles of impeachment of the committee or override its contrary resolution. The vote of each member shall be recorded. Paragraph 4. In case the verified complaint or resolution of impeachment is filed by at least 1/3 of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. Number 5, or Paragraph 5, no impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. Paragraph 6, the Senate shall have the sole power to try and decide all cases of impeachment. When sitting for that purpose, the senators shall be on oath or affirmation. When the President of the Philippines is on trial, the Chief Justice of the Supreme Court shall preside, but shall not vote. No person shall be convicted without the concurrence of 2/3 of all the members of the Senate. Paragraph 7. Judgment in cases of impeachment shall not extend further than removal from office and disqualification to hold any office under the Republic of the Philippines. But the party convicted shall nevertheless be liable and subject to prosecution, trial, and punishment according to law. Paragraph 8. The Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. Next, Section 4. The present anti-graft court, known as the Sandigan Bayan, shall continue to function and exercise its jurisdiction as now or hereafter may be provided by law. Section 5. There is hereby created the independent office of the Ombudsman, composed of the Ombudsman to be known as Tanod Bayan, 1 overall deputy, and at least 1 deputy each for Luzon, Visayas, and Mindanao. A separate deputy for the military establishment may likewise be appointed. Section 6. The officials and employees of the office of the Ombudsman, other than the deputies, shall be appointed by the Ombudsman according to the Civil Service Law. Section 7. The existing Tanod Bayan shall hereafter be known as the Office of the Special Prosecutor. It shall continue to function and exercise its powers as now or hereafter may be provided by law, except those conferred on the office of the Ombudsman created under this Constitution. Section 8. The Ombudsman and his deputies shall be natural-born citizens of the Philippines, and at the time of their appointment, at least 40 years old, of recognized probity and independence, and members of the Philippine Bar, and must not have been candidates for any elective office in the immediately preceding election. The Ombudsman must have for 10 years or more been a judge or engaged in the practice of law in the Philippines. During their tenure, they shall be the subject to the same disqualifications and prohibitions as provided for in Section 2 of Article 9A of this Constitution. Section 9, the Ombudsman and his deputies shall be appointed by the President from a list of at least 6 nominees prepared by the Judicial and Bar Council, and from a list of 3 nominees for every vacancy thereafter. Such appointments shall require no confirmation. All vacancies shall be filled within 3 months after they occur. Section 10, the Ombudsman and his deputies shall have the rank of chairman and members, respectively, of the constitutional commissions, and they shall receive the same salary, which shall not be decreased during their term of office. Section 11, the Ombudsman and his deputies shall serve for a term of 7 years without reappointment. They shall not be qualified to run for any office in the election immediately succeeding their cessation from office. Section 12, the Ombudsman and his deputies, as protectors of the people, shall act promptly on complaints filed in any form or manner against public officials or employees of the government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations, and shall, in appropriate cases, notify the complainants of the action taken and the result thereof. Section 13. The office of the Ombudsman shall have the following powers, functions, and duties. Number 1. Investigate on its own or on complaint by any person, any act or omission of any public official, employee, office, or agency when such act or omission appears to be illegal, unjust, improper, or inefficient. 2. Direct upon complaint or at its own instance any public official or employee of the government or any subdivision, agency, or instrumentality thereof, as well as of any government-owned or controlled corporation with original charter, to perform and expedite any act or duty required by law, or to stop, prevent, and correct any abuse or impropriety in the performance of duties. Number 3, direct the officer concerned to take appropriate action against a public official or employee at fault and recommend his removal, suspension, demotion, fine, censure, or prosecution, and ensure compliance therewith. 4. Direct the officers concerned in any appropriate case and subject to such limitations as may be provided by law to furnish it with copies of documents relating to contracts or transactions entered into by his office involving the disbursement or use of public funds or properties, and report any irregularity in the Commission on Audit for appropriate action. 5. Request any government agency for assistance and information necessary in the discharge of its responsibilities, and to examine, if necessary, pertinent records and documents. Number 6, publicize matters covered by its investigation when circumstances so warrant with due prudence. Number 7, determine the causes of inefficiency, red tape, mismanagement, fraud, and corruption in the government and make recommendations for their elimination and the observance of high standards of ethics and efficiency. Number 8, promulgate its rules of procedure and exercise such other powers or perform such functions or duties as may be provided by law. Section 14, the office of the Ombudsman shall enjoy fiscal autonomy. Its approved annual appropriations shall be automatically and regularly released. Section 15, the right of the state to recover properties unlawfully acquired by public officials or employees from them or from their nominees or transferees shall not be barred by prescription, laches, or estoppel. Next, section 16, no loan, guarantee, or other form of financial accommodation for any business purpose may be granted directly or indirectly by any government-owned or controlled bank or financial institution to the President, the Vice President, the members of the Cabinet, the Congress, the Supreme Court, and the Constitutional Commissions, the Ombudsman, or to any firm or entity in which they have controlling interest during their tenure. Section 17, a public officer or employee shall, upon assumption of office and as often thereafter as may be required by law, submit a declaration under oath of his assets, liabilities, and net worth. In the case of the President, the Vice President, the members of the Cabinet, the Congress, the Supreme Court, the Constitutional Commissions, and other constitutional office and officers of the armed forces with general or flag rank, the declaration shall be disclosed to the public in the manner provided by law. Section 18, public officers and employees owe the state and this Constitution allegiance at all times, and any public officer or employee who seeks to change his citizenship or acquire the status of an immigrant of another country during his tenure shall be dealt with by law.